Hello everyone and welcome to the Firearm Firm channel. Today we are going to be discussing the Second Amendment rights of 18 to 20-year-old law-abiding citizens here in Florida to purchase firearms. But before we do, be sure to show your support for the Second Amendment by clicking on the like button. Also, if you have not already done so, be sure to subscribe to the Firearm Firm channel by clicking on that subscribe icon in the lower right-hand corner of this video. In response to the tragic shooting that took place at Marjory Stoneman Douglas High School in February of 2018, Governor Rick Scott signed Senate Bill 7026, known as the Marjory Stoneman Douglas High School Public Safety Act, into law. Among other things, this act created an infringement on 18 to 20-year-olds' right to bear arms under the Second Amendment and Article 1, Section 8 of the Florida Constitution, by preventing them from being able to purchase a firearm privately or from an FFL. Now, the N.R.A. filed a federal lawsuit regarding this infringement, but the district court found that the prohibition was constitutional. The N.R.A. appealed the district court's finding to the United States Court of Appeals for the 11th Circuit, and while on appeal, the U.S. Supreme Court issued a huge 2-8 victory in New York State Rifle and Pistol Association versus Bruen, leaving many to believe that the 11th Circuit would overturn the district court's ruling in the N.R.A. case. However, yesterday, March the 9th, 2023, the 11th Circuit Court of Appeals finally released their order on the N.R.A. lawsuit, and I was completely shocked and disappointed after reading it. The 11th Circuit's 3-judge panel upheld the district court's ruling, finding that the ban on 18 to 20-year-old law-abiding citizens from purchasing firearms did not violate the Second Amendment. The 40-page opinion by the 11th Circuit Court of Appeal just completely blew my mind, and of course, I will attach a copy of it down in the description section for everyone to review it. How did they come to this conclusion after applying the standards set forth in the Bruen is absolutely mesmerizing. So does this mean 18 to 20-year-old law-abiding citizens in Florida will never be able to purchase a firearm? Not necessarily. In fact, today, 11th Circuit Court of Appeals judge who was not part of the 3-judge panel has asked for a poll to be taken, which will allow the other judges from the 11th Circuit Court of Appeals to decide if they want to hear this issue in an en banc hearing. If, however, for some odd reason they decide not to do it, the N.R.A. can seek to have an en banc hearing so that all of the judges on the 11th Circuit Court of Appeals can weigh in on this issue. However, the matter could end up being moot regardless of who asked for an en banc hearing. Why? Because this past Monday, March the 6th, 2023, House Bill 1543 was introduced into Florida's House of Representatives. If House Bill 1543 was signed into law, it would amend the Marjory Stoneman Douglas High School Public Safety Act to allow those law-abiding citizens between the age of 18 to 20 to purchase a firearm. If you have any questions about the recent disappointing 11th Circuit Court of Appeals opinion or House Bill 1543, be sure to leave them down in the comments section below, or you can email us directly at questions@thefirearmfirm.com. Until next time, stay armed and educated.